Welcome back again to the business law course. This is the third section of the labor law topic. Still with me, your lecturer, Sujana Dhanandi speaking. And in this third part, we are going to focus on discussing about the industrial relation dispute. The previous lesson, we have tried to distinguish and try to recognize two main relations in in labor law. So the first one, we got the working relation, or some translation call it employment relation. The point of this kind of relation is about the relations between the employee and the employer based on a working agreement that would accrues the right and obligation. Both parties in an employment relation or working relation, of course, they expect the running of this relation would be fine, that everything would be okay, that both parties will fulfill their obligation, so then the other party could gain their rights based on these relations. So if that were the case, then there's no problem, because at the end everybody would be happy. However, sometimes that's not always the factual situations. Sometimes the employee doesn't fulfill their obligation, or maybe the employer doesn't fulfill their obligation, or maybe sometimes the employer make a regulation or committed to a certain actions that for the employee it bring disadvantages for them, so they are going to fight that decisions or that kind of policy. So when there is a problem in the fulfillment of the working agreement or the running of the working conducted by the labor or the employee, so it could be there is a problem here. And if the problem cannot be settled, solved before it become a dispute, so then there will be some fighting for right here. And when the employee or the employee is fighting for their right in a working relations, so they could also involve the government here, whether as the supervisor or the law enforcer. And when it happened, it would brings the dispute called industrial dispute. Once again, it's called industrial dispute because when it become a dispute, it will be settled by involving the government, whether as the mediator or the enforcer. So there are 4 classifications based on Law 13/2003, and I want you to open it now because I'll actually to take a look at a certain part in that law. Yeah, I'll write it here again. Law number 13/2003, Indonesian law, Indonesian labor law. There are 4 classifications. The first one is the rights dispute, sengketa hak in Indonesia. This dispute could be happen when the right of a certain party, it could be the employee or the employer, is not fulfilled by the opponents. Let's say that you are a worker, your salary is 5 million, for example, but then after the day of the payment of the wage, the company doesn't pay the money. Okay, they say this is COVID-19, we got some problems, no sales, so no money, but we will pay it later. They say, okay, you wait, but after 3 months still they don't pay it. So you are going to violate, you're asking them to pay, but they don't want to pay. So now there is a dispute here. So it's called dispute of right, or the right dispute. It happens because there is a certain right that's not fulfilled. Or maybe the opposite situation is you doesn't come to the company to work, so the employer feel disadvantaged because now, because you are one of the staff, you're not working, so the production is reduced. So they're asking you to work because this is their right. This is the employer right to be served by you. But if you don't want to work, maybe you got another job, or maybe you lazy, so the employer can fight it, can asking you to pay some compensation, and it would be a right dispute. The second types of the dispute is the interest dispute, or sengketa pentingan. So the interest dispute could be happen because a certain interest of a certain party is harmed by the other party. Usually it happens because the employee disagree with the policy made by the employer. For example, the company make a new regulation that you are not allowed to smoke in all area of the company, of the factory. So that kind of regulation was not exist before. So when the policy is made, many men labor, yeah, the male labor disagree with this, and they unite to fight this, to change these policies to let them keep on smoking. So you can communicate with the company, say your objection. If they approve your objection, then maybe they will revoke the regulation. But if not, then you can fight it to the court. It would be the interest dispute. Or maybe there are another policy. For example, the company now make a new regulations that its employee must get at least 3 night shift per week. Well, before you only have obligation to get 2 shift a night shift per week. For the third and the fourth one, it could be overtime. But now, uh, you in 1 week you must at least 3 night shift. So this is a new regulation of the company. So if you are the employee, if you agree, so no problem. But if you disagree with this policy, so this is affecting your interest. So you can fight for it. You can fight it directly to the company, or if the company doesn't give what the solution you are asking, then you can go to the court, to the industrial court, to fight in the interest dispute. The third one is the termination of employment relation. In Indonesia, we call it sengketa pemutusan hubungan kerja. So it could be happen when an employee, the contract is terminated, or maybe they are retired, but the company doesn't pay the money they should gain appropriately based on the law. So to check it, I'll give you 20 seconds to open article 156 to check how to calculate the money that should be paid by the company when there is a PHK, or the termination of the employment relation. I give you 20 seconds. Okay, so based on article 156, there is the calculation. How much money should the company pay when they terminate your position from your job? Let's say that you already work 9 years, and then because the company having some problems with the finance because of the COVID-19, for example, so they have to terminate several employees, and you are one of them. So you are terminated after 9 years working in the company with the last salary 10 million rupiah, for example. So based on what the law said, now you can calculate how much the company should pay you the money. Take a look at the regulation, Article 156, Paragraph 2 and Paragraph 3. So 9 years, it means that the company should pay you 9 months wage for the severance money. Yeah, so it's about 19 million. Plus, for the reward money, it's about 4 months wages. So at least the company should pay you 130 million. Plus another kind of compensation if it is agreed in the working agreement before. Or maybe the company has the regulation about it. They have a scam about the termination of the contract, additional money. But at least based on the law, it's 130. Yeah. So then if the company only pay you 50, so now it's back to you. If you accept it, no problem. But if you don't accept it, so there will be some fact here. It's called termination of employment relation dispute. So you can fight your right, the rest of the money, 80 million, to the court if you cannot find a solution with the company. So that's the third one. And the fourth one is the dispute among labor union versus labor union. So in a company, usually some company, big company especially, they have not only 5 or 10 employees, but they maybe have hundreds or thousands. So these employees, they can make a union, can make an organization, and this organization called labor union, and based on Indonesian law, labor union, they has right to represent all the employees to negotiate with the employer for certain things. And sometimes in one company, they have more than one union. Let's say they have two unions. But then there is a situation that they want to discuss with the employer, maybe about the wages or maybe about the facilities, about the policy. But there is only one of them that could discuss with the employer. So if they can find a solution, one of them want to give it up to the other one, so no problem. But sometimes both union forced to be the one who represent all employees to discuss with the employer. So if the both union cannot solve it by themselves, they can also asking the court to finish it. They can ask the government to settle who has the right to represent the employees. So it would be called as the labor union versus labor union dispute. So here are 4 classification of industrial dispute in labor law. The first one is about the right. If your right is not given, it could be wages, facilities that's been agreed in the contract, and also based on the law. For example, you have 12 days off in a year, but they only give you 6 or 10, so you can fight it. This is your right. And then also the interest, maybe the company make a certain policy, a certain regulations that uh, bring you disadvantage, maybe about the code of conduct or regarding about the the regulations about the shift or another things that could affect your interest. The third one is about the termination of the employment dispute, which is talking about what the company should pay you, and the termination is happen. If it is not fulfilled as what the law already said, then you can fight it. Then there will be a dispute, sengketa about it. It's called termination of employment relation dispute. And the last one is about union versus union. I think this is one of the most main part for you to understand, because one day you become a businessman or maybe you become a worker in a company. All you need to know is about this to protect yourself, to protect your company, and to know is there any problem that could be brought to the court between you and the employee or the employer. I hope you also try to read the books and also the regulation to understand about it better. Repeat and repeat again. Remember, repetition makes you perfect. I will see you again at the next part of this topic. Thank you.